Hi everyone, so in the next video now we'll be covering question number 5A and 5B in civil paper AP JCJ mains examination. So going to the questions, 5A, what is the difference between a decree of nullity of marriage and a decree of dissolution of marriage? So here they are asking the difference between decree of nullity of marriage and also for a decree of dissolution of marriage. So before we go into the question, you can understand by seeing the question itself. So a decree of nullity is nothing but annulment and it is void from the beginning. So it is not at all treated as marriage. And on the other side, a decree of dissolution of marriage is here at the beginning it is treated as a valid marriage, but later on after passing a decree of dissolution of marriage, which is nothing but divorce under section 13. So these fall under sections 11 and 12 where a decree of nullity has been given. So now let us know few differences. So a decree of nullity of marriage, this declares that a marriage is null and void from the beginning, as if the marriage has never existed. Whereas while you talk about decree of dissolution of marriage, which is nothing but divorce under section 13, it's commonly referred to as divorce and it is treated legally as a valid marriage. So one can apply for dissolution of marriage when they are married only, and that has been taken place, which is considered as it is existed, and this marriage was once valid but now it is being terminated, which is nothing but divorce. But here the decree which is passed by the court says that the marriage has been never existed. So this is the main difference. So let us know few grounds for nullity of the marriage. So this can be nullified on basis of grounds like bigamy, fraud, one of the partner being impotent, and wife being pregnant with some other person other than husband, where the marriage is not consummated and where the either of the party is lacking consent to marry. So these are the conditions where a decree for nullity of marriage is passed by the court. So while you look into on the other side, what are the conditions when can a decree of dissolution of marriage be passed? So these conditions are adultery, cruelty, desertion, conversion of religion, renouncing the world. So these are some of the conditions for passing a decree of dissolution of marriage. So this is the exact difference between decree of nullity and decree for a dissolution of marriage. So now we'll go to the next question. What is the difference between void and voidable marriages? So while you talk about void and voidable marriages, so void marriage is said to be under section 11 of Hindu Marriage Act, whereas voidable marriage is said to be coming under section 12 of Hindu Marriage Act. So if you go into the exact difference between these both, here the section 11 is treated as nullity or void, and this is treated as voidable, and nullity is passed, the decree for nullity is passed on opinion of either party, either one of the party. So here the conditions for under void marriages are section 5 of subclause 1 5 of subclause 4 and 5 of subclause 5 of Hindu Marriage Act, which is if any living spouse is present, that means he is living, and you cannot marry or you cannot do a second marriage if any of the spouse is living. The second one is marriage is treated as void where if it is between a prohibited relationship, and if the marriage is between Sapinda relationship, then also it comes under void marriages. So under what circumstances it is treated as voidable marriages? So as per section 12, the circumstances where it is treated as voidable marriages, if the marriage is not consummated, or if it is without consent, having unsound mind, or where the wife is pregnant with other person other than husband. So this is declared as voidable by the court, and this is treated as void ab initio. That means not considered as marriage from the very beginning itself. So here no rights or liabilities arise from such marriage because it is treated as void from the beginning. So no rights or liabilities arise from such marriage. But here in this case, the rights and liabilities subsist till the decree is given, till the decree is passed by the court. So this is the main difference between void and voidable marriage. So see you in the next video. Stay updated.